Yates, Hickenbottom, Botham.
Danny Horn, PA 1774 for plaintiff, Your Honor.
He's here. Oh, there he is. Where'd they go? Okay, they're there. Okay, what do you have as a balance now, counsel?
Rent to retain $2,007.45. Cost $160. Cost $160 for a total of $2,167.45.
And folks, you previously were denied through Hawk, is that right?
Yes, sir.
Okay. So how are we going to get this paid down or paid off?
I've been making payments, Your Honor, to bring the payment down.
Okay, but so here's what I remember. I think you were going to try to move, right? Because you at a house. When were you planning on trying to do that?
To be honest, I was trying to do that as soon as possible. I just only wanted to do it. I didn't want to have an eviction on my record as if I'm abandoning the place. We're trying to pay the cost down. We was going to, as soon as possible, Your Honor.
Okay, so what, but I need a date that you're looking to try to do that. I mean, I remember everything. I remember you don't want the eviction. You don't want that. I get it. I'm just, folks have just got to answer my question so that I can try to see what I can work out for folks. But you had indicated the end of some month. I can't recall whether it was June or July. You had said that you were trying to get yourself moved.
The end of July is actually the end of my lease.
Yeah.
So we've been already looking for a place. It's just if we get an eviction on our record and the place I'm trying to move, we're not gonna be able to move sooner.
Do you have a place to go?
Yes, sir, Your Honor.
Okay, so when you're talking about the eviction on your record, I get why you don't want it, but you keep giving me a rationale for it that's not making a lot of sense to me. Because if you've got a home to go to, that eviction on your record is not going to make a hill of beans about you being housed, right?
It's not going to make hill of beans about me being housed right now, but if I want to be housed somewhere else in 2 years, it will. An eviction stays on your record for 7 years, Your Honor.
I've been doing this for a minute, sir. I get it. All right. But okay, how are you proposing? You know what? I'm done. How are you proposing to pay this down?
To be honest, I know for a fact I was going to bring $1,600 on the 28th of this month. I was actually hoping to pay a little bit more before then to help bring it down, because the last time I paid them $1,600, I only owed them $600. So I'm hoping to pay some money along the way, Your Honor. But the whole thing is, as of right now, I get paid every week. But literally, today is the first. Literally on the 5th, my whole pay schedule switches. That's the whole problem I'm getting into. I go from my every week pay to a every 2 week pay. I just started.
Are you guys willing to work with these folks? I mean, I don't know what else to do because I can't get my questions answered.
Right, Your Honor. Last time it does look like there was a discussion potentially about a conditional dismissal. We'd be willing, and Whitaker Oates can correct me, but if we do until the 13th, which would be the normal statutory period, they've stated they have somewhere to go. If they can vacate by then on a conditional dismissal, then with this being possession only, there would be no eviction for the future, and they would still get the statutory period that they would be entitled to if there was a judgment. My client would get possession back or have the right to get a writ of eviction the next business day. So that's what I would propose, unless Whitaker Oaks has something different in order to help both parties do and achieve exactly what they want to do. Because frankly, it doesn't sound like payment's coming anytime soon.
How does it not sound like payments coming anytime soon when I just gave you guys $1,600? Before I gave you guys $1,600, I gave you guys $250. And before I gave you guys $250, I gave you guys $175. And this was and you guys just took over. This is my first time ever being late on my rent. I can't help that I got sick and I had major surgery. I was in the hospital for over a month. I can't help that. I apologize.
Mr. Yates, Hickenbottom, let me just tell you something. You're not going to come into this courtroom and try to yell at anybody.
I'm not yelling at
It's not, no, it's not going to happen. It's not going to, you want to try to overtalk me? Really? Do you want to do that today? I'll wait for your answer.
No, Your Honor, that wasn't my intent.
Here's what I'm going to do, because I'm done. I'm going to adjourn this out to the 16th over the objection of plaintiff, because I know they want their judgment today. June 16th, 2023, 9 a.m. Mr. Yates Hickenbottom, I'm just going to tell you this. Maybe you should look at the way that you approach people. Maybe you should go over to the management and try to work out a conditional dismissal. It's going to be up to them and you to work that conditional dismissal out. I'm done. If they come back, you don't have one worked out, I'm granting them a judgment, if that's what they want.
Your Honor,
I'm done. Thank you. 16, 2 weeks. Court will be in recess.
Thank you, Your Honor.
And court does call the case of the People versus Kelly Messenger.
Se ha requesto lo cordial.
I'm sorry?
Se ha requesto cuando lo cordial. Understood? Alright, that's me, Kelly Messenger. Right here, English.
Okay, if you can speak English, let's do that. Counsel, please state your appearances.
Ashley Londy standing in for Caitlin Kirby for the People.
Michael Gaddy, Assistant Public Defender on behalf of Ms. Messenger, Your Honor. Ms. Messenger, could you state your name, please?
Kelly Messenger.
All right, before we begin, I do have to arraign Ms. Messenger on an additional complaint. All right. Ms. Messenger, you have a new case before the court. The new case alleges 2 charges. It alleges that on November 19th, 2021, at the Huron Valley Correctional Facility, that you did, count 1 alleges that you did assault a prison employee. Do you understand the nature of that charge, ma'am?
I don't understand the nature, but I hear what you're saying, though.
All right, let me ask it this way. You understand that when I say assault on a prison employee, you understand what you're charged with. I'm not asking whether you did it.
I do understand.
All right. And that involves a Ashley McFarland, that on count 1. That's a felony punishable by up to 5 years incarceration and or a $2,500 fine plus court costs. Do you understand the maximum penalties?
Está de acuerdo, se le conoce. The adequate, yes, I do understand.
All right. Count 2 is the same charge alleged to have occurred on the same day involving an employee of the facility of Leisha Terrell. Do you understand that, ma'am?
I didn't hear the name.
Leisha Terrell.
Leisha Terrible?
Yes.
Sí, adequate, adequate, no. Nope. Not, I cannot accept that.
Okay,
There's no,
ma'am. I'm not, ma'am. I'm not asking you whether or not you did it. I'm asking whether or not you understand that you're charged with an assault on that person.
That name is unacceptable. There's nobody in my facility by that name.
Okay, that might be a defense to this, but do you understand that that's what you're charged with?
All right, I understand.
Okay, do you understand that? Okay.
Yes, I do.
And you understand that on that count too, it carries the same penalties I just told you, which is 5 years, $2,500 fine plus court costs. You understand that?
Yeah, I understand. I'm done tripping.
Okay.
I'm just in a foreign movie. Okay, that's my language. My native tongue. Okay. Now look, how many years does it carry? That's all I want to know.
It carries up to 5 years.
Okay, both of them 5 years.
Both charges are the same charges, just different people. Maximum penalty on each one of those charges is up to 5 years.
Yeah, look, I heard about the incident. Okay.
Okay. I don't want you, Miss Messenger. I don't want you saying anything about the incident. I just need to know what you're that you understand what you're charged with and what the maximum penalties are.
I do, but it wasn't me.
Okay.
I heard about
And that may be a defense. I just need to make sure you understand what you're charged with, what the people are saying you did.
Yeah, I hear you.
Got it? Okay. Now, my first question to you is, do you want to be represented by an attorney?
Yes.
This is a public defender case. All yours, Mr. Gady.
Yes, Your Honor. Waive further reading, stand mute to the charges. Mike Gaddy for Miss Messenger.
All right. Defendant having waived formal reading, pleading not guilty or with that plea. You also waive the time requirements, Mr. Gady.
Yes, Your Honor.
All right. Okay, so now that I've arraigned her on that charge, counsel, what are we doing with this case? I'm assuming you want them to carry along with the other cases.
That's correct, Your Honor. I'd ask the court to set this for a probable cause conference. Since we were here last time on Ms. Messenger's first probable conference, PCC on the other two matters, I have had a chance to speak with Ms. Messenger and APA Kirby. This might throw a wrinkle into things. I'd ask the court to adjourn those matters and set them for the same time as these other probable cause conferences.
All right. You want to hear these on the 21st, or you want more time than that?
Maybe a week later than that, Judge.
I'm sorry?
Maybe on the 28th, if that's available.
I have the 26th. The 28th is not available. I have a Tuesday.
I want to know who this black Bin Laden is over here. Say name, there's no name. Like some of these people in this courtroom don't make sense. It's a black Osama Bin Laden right here, TCL83, with no name. Now, who are these people in my courtroom?
Okay, first of all, it's not your courtroom, it's mine.
Well, I'm here, so it's fine for the time being.
I'm the one that sent the invitation. All right. Mr. Gaddy, what date would you like?
Why don't we do the first date in August, Judge?
August 4th. Okay.
Thank you, Your Honor.
I will adjourn the probable cause conferences till August 4th, 2022, 9 a.m. Bond on those matters will continue. On the new case, I will set her probable cause conference on August 4th, 2022 at 9 a.m. with a preliminary examination to follow. As to the defendant's bond, I will set the defendant's bond $10,000. I'll give a 10% privilege on that. She's not really going anywhere.
No, I think 2030, Judge.
Pardon?
I think 2030 according to others.
Hey, Roddy,
What is he telling me?
I'm having trouble hearing.
Yeah, mute her. All right. I've set it for August 4th. I've set her bond at $10,000 or 10%. Standard conditions, including no assaultive behavior, no alcohol, recreational marijuana, or any illegal drugs. And I'll just leave it at that. All right.
Thank you, Your Honor.
Thank you.
Thank you.
I'll be in touch, Miss Messenger.
You have fun with that. Okay, first of all, it's not your courtroom, it's mine.